building, she never looked up the envelope, was cream-colored. Heavy stock. The kind law firms use when they want the paper itself to feel like a threat. I recognized the letterhead before I opened it. Hartwell and Voss. 3rd floor. Suite 310. My stepmother, Diane, had hand-delivered it herself, which told me everything I needed to know about how much she was enjoying this. Inside was a notice to vacate. 30 days. My childhood home, the house my father built, the house I had been quietly paying the property taxes on for 6 years without telling anyone, was, according to the letter, being reclaimed by the estate for sale. Diane stood in my doorway in a blazer that cost more than my first car and told me this was simply business. Nothing personal. The estate needed liquidity, and sentiment didn't pay legal bills. She had no idea that the firm whose letterhead she was holding operated out of a building I had purchased 4 years ago. She had been paying me rent the entire time she was threatening to take my home. Before I tell you what happened when I called Hartwell and Voss myself, drop a comment and tell me where you're watching from. I want to know how far this reaches. My name is Claire. I'm 33 years old. To my stepmother, I am the inconvenient daughter from my father's first marriage, a loose end she has spent 12 years trying to tidy away. The girl who got the house in the will instead of the money. The complication she has been quietly managing since the funeral. To the commercial real estate market in this city, I am the principal of a holding company that owns 6 buildings, 4 of them downtown, one of them on the corner of 5th and Market, a mid-rise with frosted glass doors, and a directory in the lobby that lists, on the 3rd floor, Hartwell and Voss, attorneys at law. Diane had walked past my name in that lobby directory for 3 years. It was listed differently there. Not as Claire. As the holding company. She never looked twice. Why would she? Lobbies are full of names nobody reads. My father built that house in 1994, before Diane, before any of this. I grew up in it. I learned to ride a bike in that driveway. My mother died in the upstairs bedroom when I was 9, and my father never once suggested we sell the house and move somewhere that didn't hold that memory in every wall. Diane came into our lives when I was 16. She was warm at first, careful, the kind of warm that performs well at dinner parties and evaporates the moment the audience leaves. It took about 2 years for me to understand that her interest in our family had a shape, and the shape was an inventory. When my father died, sudden, a heart attack at 61, no warning, the will was simple. He'd written it himself a decade earlier, before he remarried, and somehow it had never been updated. The house went to me. Everything else, the accounts, the investments, a small rental property in the next county, went to Diane. She contested it immediately. Not loudly. Diane didn't do loud. She did it the way she did everything, through Hartwell and Voss, through carefully worded letters, through a slow, patient legal grind designed to make me exhausted enough to settle. It took 14 months, and most of my savings to keep the house. The will held. The house was mine. Diane never forgave me for winning that. She had been waiting 12 years for a second opening. The opening she found was a clause buried in my father's original trust documents, something about the property reverting to the broader estate if certain tax filings lapsed for more than 90 days. I had never lapsed on anything. I had paid every tax bill personally, quietly, through an LLC I used for several of my properties, specifically so that nobody in my family would have a reason to look closely at my finances. That LLC name on the county tax record was not Claire. It was Birchwood Holdings. Diane's attorneys found a clerical error, an old filing from the county that listed the previous year's tax payment under the wrong parcel number, making it look on paper like a lapse had occurred. It hadn't. But paper doesn't know that. Paper just says what it says until someone corrects it. Diane's attorney, a man named Russell Voss, yes, that Voss, the one whose name was on the letterhead, drafted the eviction notice and the reclamation filing inside of 9 days. He was thorough. He was confident. He had built an entire career on being the kind of lawyer who moved fast before the other side could organize. He had no idea who he was about to call. 4 years ago, I had acquired the building at 5th and Market through Birchwood Holdings, the same entity, as it happened, that held the tax records on my father's house. The building had been underperforming, half vacant, owned by a retiring landlord who wanted a clean, fast sale. I renovated the lobby, refreshed the HVAC systems, and signed several new commercial leases over the following 2 years. One of those leases, executed about 3 years ago, was with a mid-size law firm relocating from a smaller space across town, Hartwell and Voss. Russell Voss had negotiated that lease personally. He had been thorough about the tenant improvement allowance and aggressive about the parking provisions. He had been considerably less thorough about reading the entity name on the landlord's signature line, which listed only Birchwood Holdings, its authorized representative, with a signature that, admittedly, I had made deliberately unremarkable. He had been paying rent to me, increasing annually, per the escalation clause his own associate had drafted for 3 straight years. He did not know this when he filed the eviction notice against me. I found out about the filing on a Tuesday morning. I read it twice. I poured a cup of coffee, and then I called my property manager and asked her to pull the complete tenant file for Suite 310. I did not call Diane. I did not call Russell Voss directly either. I called my own attorney, Priya, who had handled every acquisition Birchwood Holdings had made for the past 6 years, and I told her what I needed. A meeting, on neutral ground, with Diane and Voss both present, ostensibly to discuss the property tax discrepancy and resolve the matter efficiently. Priya suggested we hold it at the Hartwell and Voss offices. I told her that was exactly where I wanted it held. We arrived at 4 in the afternoon. The lobby directory listed the firm on the 3rd floor, same as always. The elevator had new carpet. I remembered approving that expense 8 months earlier. Diane was already seated in the conference room when we walked in, sharp blazer, the same composed expression she'd worn in my doorway 30 days earlier. Russell Voss sat beside her, a thin associate to his left taking notes, a folder open in front of him with what I assumed was the reclamation filing. He stood to greet Priya with the easy confidence of a man who believed this meeting was a formality before his win. He looked at me with considerably less interest. To him, I was simply the other party. A name on a filing. A category. "We appreciate you being reasonable about this," Diane said, settling into her chair. "I know the house has sentimental value, but the estate has obligations, and frankly, this clerical issue has made things complicated for everyone." "It has," I agreed. Russell opened his folder. He explained at some length the tax filing discrepancy, the reversion clause, the firm's position that the property should revert to the estate pending resolution. He used the phrase, "in everyone's best interest," twice. Priya let him finish completely. She is very good at letting people finish completely. Then she opened her own folder. "Before we go further," Priya said, "I'd like to clarify something about the entity involved in this filing." She slid a single document across the table. The county tax record, corrected, with the clerical error clearly identified, and a letter from the assessor's office confirming the original payment had, in fact, been made on time, attributed to the wrong parcel due to an internal county error. "The reversion clause was never triggered," she said. "There's no lapse. This filing is based on a documentation error, not a fact." Russell's expression flickered the first small crack, but he recovered quickly. "That's a county matter. We'll need to verify that independently, but even if true, it doesn't change the underlying ownership question. The estate trust still has a claim to." "It doesn't," Priya said. "But I want to address something else first, since we're here, in this office." She turned a page. "Mr. Voss, can you tell me who holds the lease on this suite?" Russell blinked. "I'm sorry. This suite. Your firm's office. Who is the landlord on record?" He glanced at his associate, who shuffled through papers and said quietly, "Birchwood Holdings." The room went very still. I watched Russell's mind do the thing minds do when 2 unrelated facts suddenly, violently connect. Birchwood Holdings. The name on his own lease. The name on the county tax record he had just spent 9 days building a legal filing against. Diane looked between Russell and the document, not yet understanding, the way a person doesn't understand a translated sentence until someone says it slowly, in their own language. "Birchwood Holdings," I said, "is my company." Nobody spoke. "I purchased this building 4 years ago. I approved the renovation budget for this floor. I approved your tenant improvement allowance personally, although I'm sure you negotiated it with my property manager and never had a reason to ask who signed off on it. I let that settle. You've been paying rent to me, with annual increases for 3 years. Tonight, in your own conference room, your firm filed an eviction notice against your landlord. Russell set his pen down very carefully, the way you set down something that might be hot. Diane said, "That's not," and then stopped because there was no sentence that finished that thought in a way that helped her. I want to be clear about what I did and didn't do in that room. I didn't gloat. I didn't raise my voice. I had spent 12 years watching Diane manage every interaction with precision and control, and I had learned, mostly from her, that the most effective thing you can do in a room like that is simply let the facts exist in the air until everyone finishes catching up to them. Russell asked for a recess. He stepped into the hallway with his associate. I heard, faintly, the particular tone of a man explaining something to a junior colleague that he wishes he didn't have to say out loud. Diane stayed in the room. For the first time in 12 years, I watched her run out of a prepared response. She looked at the document. She looked at me. She said finally, quietly, "I didn't know." "I know you didn't," I said. "You never looked. Why did you tell anyone about any of this?" I thought about that question for a moment because it deserved an honest answer. "Because the first time I told this family something I'd built, you tried to take the house instead of celebrating it," I said. "I learned to stop announcing things. I just built them quietly and let them hold their own weight." She didn't have anything for that. I'm not sure there was anything to have. Priya and I withdrew the discussion of damages. I had no interest in punishing the firm financially, and I told Russell as much when he returned to the room, considerably less composed than when we'd arrived. I simply asked that the reclamation filing be withdrawn in writing within 5 business days, and that the county error be formally corrected on record, which Priya would assist with directly. Russell agreed. He didn't really have another option. I left the building a little past 6. The lobby was quiet, the directory glowing faintly under its recessed lighting, my entity's name sitting there in small type where it had sat for 4 years, unread, unremarkable, true. I drove out to the house that evening, the one with the driveway I learned to ride a bike on, the one with my mother's old bedroom upstairs that I still couldn't bring myself to repaint. I sat on the porch, steps for a while in the dark. I didn't feel triumphant. I felt the specific quiet of a thing finally settled, the kind of quiet that doesn't need anyone else in the room to confirm it's real. The house was still mine. It always had been. She just never read the paperwork closely enough to know it.